Right, good afternoon, everybody, and welcome to this seminar on special educational needs in the First Tier Tribunal. Firstly, we are recording this seminar, and the link will be made available after the seminar is finished, and it's going to be up for at least a couple of weeks, so you can go back and watch the whole thing again if you feel like it. I'm Charlotte Hadfield. Some of you may already know me. I am the head of 3PB's education team. I specialise in education, discrimination and employment, and I'm presenting today with Aimee Fox, who specialises in education and family law. As a set, we're nationally ranked for expertise in all areas of education, and we hope that we're going to be able to give you some useful information about SENDist appeals, as well as answering any questions that you have about the law in this area, any specific questions that have arisen out of your practice. Aimee is going to take you through the basics of EHC plans, the mechanism for challenging the content of an EHC plan, and how to approach sections B and F of the plan, needs and provision. And then I'm going to conclude the talk with some discussion about section I, the school that's named in the EHC plan, and then we'll answer any questions that have come up. There is a chat facility on Zoom. I feel very, very old. I'm really saying that for myself more than anybody else because I'm so sort of technologically challenged, but there is a chat mechanism on Zoom. And I think probably the best way to deal with questions is if you put any questions that come up in the chat box, and we'll come back to them and answer them at the end. If you don't think of your question during the seminar, but you think of something you'd like to ask afterwards, please do feel free to email either or both of us with your question, and we'll let you know what we think. So I'm now going to hand over to Aimee to talk about EHC plans.
I practice, as Charlotte said, in family and education, and certainly I think I said to some of you and your colleagues on the last occasion, what I've learned through my education practice has really, really helped my family practice. I don't think that the family court is as up to speed with special educational needs as really it ought to be. It's certainly difficult sometimes for the court to grapple with when having to make decisions about or concerning a child with special educational needs. So again, in this session, I hope it helps you if you have clients coming to you who might be thinking of the softer approach with the local authority that we looked at last time, or perhaps want to go ahead and challenge their local authority in respect of school place that Charlotte will be dealing with, or therapies and other provision that they feel their child might need. So the slides will be available to you. They'll be sent out after, so don't worry about having to make a note. So the basics, we're going to start with looking at what an EHCP or Education, Health and Care Plan ought to look like. They should all follow the same basic structure, although up and down the country, you have all sorts of weird and wonderful designs and logos and can be slightly confusing, but they all have the same content in sections A, B, C, and so on. It's not like our Mostyn templates or other templates. There is still a certain amount of freestyling, so you do have to navigate your way around these documents a little bit. So in essence, section A is going to record the views, the interests, the aspirations of the child, the parents, or of the young person. This has proved quite a fruitful area for evidence in the family court, because you might find a child or a family expressing views potentially about how important dad is or grandparents are to that child, which is then later denied in family court. So if you have those sorts of issues, section A can be quite useful. Section B should describe the child or young person's special educational needs. Section C will be health needs. D is social care needs, which relate to the special education need or disability. Section E is outcomes. So that's always a box that looks at where everyone would like the child to be by the time of the next plan. So what should this child, what are we all hoping this child will be able to achieve by putting the provision in this plan. Then section F will detail the special educational provision. So you might find things in there like weekly speech and language, weekly occupational therapy, right down to how the curriculum should be delivered, or even the class size that the child should be a part of. Section B and F are absolutely critical. And section F is essential because anything that is inserted into section F must be provided. And if the local authority doesn't provide what it has said it will in section F, then it's susceptible to complaint and judicial review. So you may find clients come to you, those with a bit of knowledge about the system, and they will want to have their therapies and as much provision as they can slotted into section F. We'll talk more about the sections as we go along. G again is health provision. H1 is another type of social care provision. H2 is other social care provision. Section I is the placement. Charlotte will speak to you about that. Section J is personal budget. And section K is really a summary of advice and information. So that's how the plan ought to look. We spoke last time about some of the softer approaches to trying to get your local authority on board. If that fails, you can, of course, appeal to the first tier tribunal. It's relatively informal, although it differs quite a lot from the family court in that it really is dominated by experts and expert evidence. Whereas we've got to try quite hard sometimes in family under Part 25 to introduce expert evidence. You will find that this is very much a jurisdiction that is expert heavy. So you could go to an appeal with an educational psychologist on each side, physiotherapist on each side, speech and language therapist on each side. So you've got 6 experts. We don't in the Education Tribunal have the same concept of SJEs that we do in family, where really your first port of call is to instruct an SJE, and potentially to have your own expert, you're going to have to make applications in finance if it's Daniels and Walker or something like that. Very, very different here. You will have to deal with expert evidence that can feel not particularly intuitive when you start this area of practice, because you might not have come across occupational therapy, testing evidence, speech and language therapy before. So it's really useful to be able to have a guide. And on the last occasion, Naomi and I provided just a short list of acronyms to help you navigate if you start out in education law. The tribunal works so that it's usually a panel of 2 or 3. The chair will be an education law expert, most often a practicing lawyer. The other panel members will have some experience or background in education. So again, this is not the equivalent of going before 3 lay magistrates. It's an expert tribunal. The default position is the tribunal only has power to make binding decisions in respect of sections B, F, and I. B is about the child's special educational needs. F is about what's going to be put in place to meet those needs. And I is the educational placement. They can get involved in amending outcomes, what the child or others are aspiring for the child over the course of the next year or so on. but that's really only if the plan would be unworkable. So you don't tend to find them becoming very heavily involved in that section of the plan. We've had a national trial, so it's now open to the tribunal to make non-binding recommendations for health and social care. So really the aim is to try to find more of a one-stop shop for young people and families. But again, be mindful of the fact that on the health and social care element, it's only recommendations and those aren't binding. The sections B and F I've already outlined are really important parts of the plan from an education perspective. We'll look at some of the content. So I'm just got my slides slightly cut off, so I'll look at my paper copy. So the regulations say that when preparing an EHC plan, a local authority must set out the child or young person's special educational needs and the special educational provision required by the child or young person. So nothing new there. That's what we've already identified. But as you might imagine, can generate an awful lot of litigation because what the local authority says should be provided may not be what family thinks ought to be provided. Oftentimes, people will have gone off and commissioned their own independent reports. And that will assist them in trying to go to the authority and say, we think you've got this wrong because we've got an expert telling us that instead of having speech and language therapy once every 3 weeks, it needs to be every week. So this is really an important part of your case strategy if you go to tribunal, to make sure that you are equipped with all the evidence that you can get from independent experts. So I've said already that section B contains a description of the child or young person's special educational needs. What you will probably find there are lists of diagnoses, or perhaps just a single diagnosis that gives rise to the child or young person's special educational needs. You might also find a narrative description of the child. There are some of these plans can run to 40 or more pages, and the expert reports that have fed into the plan are often attached. So it's a real balancing exercise between putting enough information in the plan to make it helpful to whoever is working with the child, and then trying to avoid it becoming unwieldy and no longer being user-friendly. You will find lots of different terminology. And what the tribunal has said here in Hillingdon in G, description, there's lots of descriptions all through plans in section B. When describing cognitive impairments, the learning difficulty can be categorized as severe, moderate, or mild. There is no such thing as a significant learning difficulty. So although lay people may talk about a significant learning difficulty, it's just one to watch out for in terms of knowing what language the tribunal and experts will use. I've touched upon this already in respect of section B. It's about keeping it brief, concise, and to the point. As I've said already, the expert reports will be appendices to the plan, so they will always be available to staff, or should always be available to staff if they need them. The one thing that you might struggle with is managing client expectations as to how much goes in. it can be a very natural and understandable tendency for parents or carers to want to just put as much as they possibly can in. But really, you've got to find that balance so that it doesn't become unwieldy. Think about the different people who will be reading the plan, particularly if the child or young person is in a mainstream school. Some of the staff may not be familiar with the diagnosis, may not have worked with the diagnosis before. So it's about making sure that the audience understands it. Include information from independent experts as well as local authority experts if that's agreed. It's not always the case that experts disagree on everything. Sometimes you find common ground between experts where you can find agreed forms of wording. Another thing to watch out for in a plan is not to put provision in section B. Section F is for provision. Section F will be what the child is entitled to and what the child will be provided to meet the needs set out in section B. I've said there, don't use verbose wording unnecessarily, just keep it factual and keep it straightforward. Finally, don't include excessive extracts from expert reports or standardized test results unless specifically relevant. All of these things are important because if you go off to tribunal on a section B and F appeal, if you are arguing about whether or not the local authority has got the child's needs right and the provision to meet those needs right, then you are likely, you are probably going to have two different versions of an EHCP, what you would like it to look like and what the authority would like it to look like. And what we do is we have a working document. So effectively, it might be, so if you think of, if you had a draft child arrangements order and you had mum and dad, or all of mum's arrangements, and you had all of dad's, and the court would be working through to decide which ones should be kept in and which ones should be removed. That's the idea. Both parties' proposals go into one document. You see that parent or carer will have a particular type of font, bold, local authority will have italics. So you get a document and you can see where the fault lines are, and you will work through that document with a client. There might be 10 or 11 versions of that document before you even get to the tribunal door, because what the tribunal will expect people to do is to try to narrow the issues as much as they can. So sometimes local authority will sit down with its experts and say, what do you think about that? Can we agree that? So you're trying then to reach agreement where you can, and then you can see where the issues remain for determination. So getting these things right, about being concise, not avoiding excessive extracts, etc. It might avoid flashpoints and might mean that you can agree a bit more, because some of an authority's objection might not be on the substantive point, but rather, oh, that's much too long, or that's repetition, things like that. Section F contains the special educational provision required to meet the child or young person's needs. B and F need to match. It needs to be a coherent document. So if you have a child who is struggling with communication in B, then you will probably find that if that's described as a need, that you want to put something in F that is provision to meet that need. So here is the issue, and here's how we think we can remedy it. So it really needs to be coherent. One thing that local authorities will often rely on is the fact that the local authority is under a legal obligation to meet the needs of the child, no more, no less. We often use, I'm not sure if I've cited it here, about not having to provide utopian, absolute best education available. All they have to do is, oh, it is there, the utopian system quote, or even to educate him or her to a maximum potential. It's about meeting needs. The paramountcy principle under the Children Act does not apply. These are not best interest decisions. These are decisions based on the challenges that a child might have and how the local authority will meet those challenges or help the child and support the child. It's not best interests. Provision, said in Buckinghamshire and SJ, is not just about qualifications. Obtaining qualifications isn't actually an essential element of education. I think that's probably quite different to what most lay people will think of as education in the UK. You might find a local authority who isn't quite sure what a child should be receiving, saying that they'll provide an assessment. Well, provision ought not to be left and dealt with at a future assessment. Finally, an important point, and one that can sometimes be a little bit tricky to just to grasp, is health or social care provision can be educational provision. So that's a concept that we argue about quite a lot in tribunal. I've already talked about section F, and that if a therapy is in section F, the local authority must provide it. And the buck really stops with the local authority. That's why it's desirable for family to have as much in section F, shoehorned into section F as possible, because they know that they want that enforceability. You've then got the health or social care provision where the tribunal can make recommendations. But we sometimes get into arguments about, well, is that really education? Should that really be going into section F? The local authority might think not. What amounts to education, I think, is an increasingly wide definition. It embraces an awful lot. It embraces things that might surprise you. You might pick it up and first blush think, well, that's obviously social care, that's not education. But you find that the tribunal takes a different view. The health or social care provision can be education if it educates or trains a child. We also, in tribunal, once we get over what sections therapies and other provision ought to go into, we have arguments about specificity. It's really important that your EHC plan is specific because you want it to be enforceable. You want to know what's being provided, when, and by whom. So you will probably, a good example would be a speech and language, 60 minutes, once a week, provided by a speech and language therapist. You would build into that when they're going to review the program, how much time they'll build into doing a final piece of work before the whole plan gets looked at again on a yearly basis. So you don't want things left open unnecessarily. You want to be able to pick up a plan and answer those questions Who's providing it? When? How long? And what exactly is it? There's quite a bit of case law on this point because it's often contentious. The code of practice says provision must be detailed, specific, normally be quantified in terms of the type, hours, frequency of support, and level of expertise. There is some room where a child is potentially going to a very specialist setting where things don't need to be in quite the same level of detail, but you do still have to be careful there. The case that's often used is L. Clark and Somerset. The real question is whether the EHC plan is so specific and so clear as to leave no room for doubt as to what is being decided and what is needed in the individual case. If a local authority has a policy not to specify provision, that would be unlawful. There's the law. Everybody's got to be specific. I have been rather bold in my final bullet point and described expert reports that don't provide specific guidance as useless. It's really important that if you are instructing an expert, that they understand the need to assess the child, they're doing that, and make recommendations or conclusions that will sit easily into, or be easily transferred into an EHC plan. You don't want vague recommendations. In fact, they should really be using that case and the relevant section of the Code of Practice to guide them in terms of the level of information that the tribunal will need in order to make a determination. If not, they don't do that, it's awkward. They will be put under pressure on the day to try to come up with something, and it looks like it's not been very well thought through. It's a very established principle that the tribunal requires specificity. So ignore that at your peril is what I would say to an expert. Why do we prioritize specification? It's got to be clear. It's got to be clear to staff and those working with the child what they need to do, when they need to do it, and who's doing it. Also, it's to avoid funding considerations. So if it's specific, the authority's got to provide it, got to be providing that once a week speech and language, got to be providing the other bits and pieces that you'll find in section F. I've said already that if section F isn't followed by the local authority, then they can be challenged by way of judicial review. You will sometimes find that the threat of judicial review is enough to prompt the local authority to make sure that it is putting what it needs to in place. There are cases where there's been a change of staff or something has happened with a particular provider and things slip. But it's as simple as the buck stops with the local authority for section F. They've got to make sure that it happens. Can there ever be flexibility? Touched on this already. Yes, but it needs to be based on the child's needs or because of the interaction between the child and the child's environment. And it cannot be left to allow for flexibility simply in the school's approach or arrangement. So yes, you can have flexibility, but it's got to be used carefully and not simply left. That's it on section B and F. I think Charlotte is going to come in now on section I. Of course, if Charlotte has any thoughts on B and F, they're most welcome.
Right, thanks very much, Aimee. So I'm going to talk about Section I, which relates to the school that is named in the EHC plan. So I'm going to start by talking about naming parental preference and what that means under the Act. So there are two sections that are of particular importance here. Section 39(3) of the Children and Families Act says that the local authority must name parental preference. So if a parent identifies a school, let's assume for a moment that there's no disagreement between parents as to which school will be identified. If there is a clear parental preference for one school, the presumption is that the local authority must name that school unless it is unsuitable for the child, having regard to the child's special educational needs, incompatible with the efficient education of others, or incompatible with the efficient use of resources. And Section 33 of the same Act says that if parents ask for a mainstream school, the local authority must name that mainstream school unless, again, it is incompatible with the wishes of the child's parent or young person, or it's incompatible with the provision of efficient education for others. And I think the particular point to note about Section 33 is that if parents ask for a mainstream school for their child, the LA has to name that school, even if it doesn't think that the school is suitable for the child. The Act then goes on to say that the LA must make such provision as is reasonably required in order to make that school suitable. But it's striking, I think, that there is this presumption of mainstream education in the Act, so that if parents ask for a mainstream school, they get it even if everybody who looks at that child thinks this child shouldn't really be in mainstream education. So what schools can be named in an EHC plan under Section I? So maintained schools, academies, non-maintained special schools, which are special schools who receive funding under a funding agreement from the EFA, and independent schools that are approved under Section 41 of the Education Act can all be named in an EHC plan by the local authority or by the tribunal. And the particular thing to bear in mind is that they can be named even if they don't want to offer a place. So the local authority or tribunal can decide that those schools can meet need, even if those schools take the view that they can't and say that they don't want to offer a place or that they're full. You can also name an independent school that isn't approved under Section 41 of the Education Act, but those schools can only be named if they offer a place. So only if they agree to take the child. If they don't agree to take the child, then the tribunal and local authority cannot name that school in the plan. It is common for special schools to ask to assess the child before they offer a place, whether they're approved under Section 41 or not. And so it's quite common for a school to say, you know, let's give this child a taster session. So that could be a day or a few days, attending on a day basis. Or residential schools will often offer a residential taster where the child stays there overnight for one or more nights to see how they fit in. So those are the schools that can be named in the EHC plan. The other thing to bear in mind is that sometimes, and I'm sure that everybody listening is familiar with this, sometimes parents do not agree about which school their child should go to, particularly if the parents are separated or divorced. And there may be concurrent proceedings going on, of course, in the family court that might specifically relate to which school the child should go to. So as far as the first tier tribunal is concerned, the Children and Families Act just talks about a parental preference. And so that's generally understood to mean that both parents can name a preference, and that preference does not have to be the same. What happens in practice tends to be that one parent agrees with the local authority about the school that should be named and the other parent doesn't. That's quite common. It's not necessarily the case. You could have three schools on the table, one from each parent and one from the LA. But what has tended to happen in my experience is that one parent is very enthusiastic about the LA's choice and the other parent wants to name a different school. Sometimes these disputes are about disagreement in relation to what the child needs. Quite commonly, they are about logistics in terms of transport. So particularly if parents perhaps don't necessarily live in the same area, if they have shared custody, there tends to be a difficulty where one parent is going to be driving for a sort of 2-hour round trip every morning and the other parent is only going to have to go 5 minutes away. So where this happens in the first tier tribunal, the common practice is that the parents will be joined separately as parties and the tribunal will make a decision as to which school can meet need. Now, sometimes it's the case that all the proposed schools can meet need. And in that situation, what the tribunal might do is name a type of school. and then leave it to the family court to make an order determining the school that the child should attend. Or perhaps two parties are naming maintained schools, one party is naming an independent school, the tribunal decides that a maintained school can meet need, and so the tribunal might say, we're just going to put a type of school in section I, because the tribunal is allowed to do that, as is the local authority under the Act, and the parties can go to the family court if they want an order determining the school that the child should attend. And then the family court, one assumes, would make that order in light of the tribunal's determination of what would meet need. If you want to look at a case that considers in detail what the tribunal should do where there is a disagreement between parents, a good case to start with is the case of SG against Denbighshire County Council, which is a 2016 case in the upper tribunal, and I will pop that in the chat box when I get a minute. But that is a good place. That is a good place to start when you're thinking about a situation where parents are at loggerheads as well as being at loggerheads with the LA. So going on to parent school being unsuitable, most commonly, the local authority, it's relatively unusual for the local authority to say that parent school just can't meet need. At least that's the case where the parents are represented. Where parents are representing themselves, you do sometimes see parents having nominated a school that isn't appropriate, but generally speaking, where the LA has concerns that the parental preference can't meet the child's special educational needs, they will say that it's just unsuitable. Where the LA's concern is that the school is more than the child needs, so you sometimes see local authorities saying this is over provision, the child doesn't need this, that we would say is not a situation where the school can't meet need, because it is meeting need, it's just providing extra. And we would say, and generally speaking, the tribunal will say, that's more an issue about whether the school's an efficient use of resources. So should it be that school, or should it be another school that can provide need at a better cost and without add-ons that are taking the cost higher than it needs to be? When we're talking about a school being unsuitable, and this applies both to the parent's choice of school and to the local authority's choice of school, we tend to look at various different aspects of what the school offers. So you start by looking at the designation of school. And we do note here the cohort sometimes changes before designation, so it's not unheard of to find yourself in a tribunal hearing where a school is still identified by, say, Ofsted as being an SEMH school, so a school for children with social, emotional and mental health difficulties, but there's been what we call cohort creep. And so in practice, they're now really catering for pupils with ASD rather than pupils with social and emotional problems. Or sometimes you can get a situation where a school that was for students with profound disabilities has drifted to a point where it's MLD. I don't want to get into the kind of technicalities of what the cohort would look like, but that is sometimes something that can happen. So the designation of the school as identified by Ofsted is a good starting point, but it doesn't necessarily need to tell you what you need to know about the cohort. Cohort and peer group are really important. So when we talk about peer group, we're talking about who a student will be educated with. And various different concerns come into play there. So questions that I often like to ask when I'm thinking about whether a school is suitable is, what's this child's cognitive ability? And if he were to go into an identified class, because normally the school under consideration will have an idea of which class they would go into, where would they be in that class? Would they be far ahead of everybody in the class cognitively? If they would be, let's say you've got a child who's working at age-related expectations, notwithstanding their special needs, and it's proposed that they go into a class of children who are working 2 years behind age-related expectations. That, on the face of it, wouldn't be a correct peer group for that child. How verbal is that child, and how verbal are the other children in the group? So, for example, if your child is going to be the only verbal child in a group of children who aren't verbalizing yet, or if your child is going to be the only non-verbal child in a group of peers who can communicate with each other verbally, again, that doesn't look like a great indication. What are the primary needs of the peer group? If you have a child with autistic spectrum disorder, and let's say they have a profile like a demand avoidant profile or something like that, that makes their autism perhaps different from classic autism, you would be concerned, I think, if it was proposed that they go into a class full of children with social and emotional difficulties who didn't have autism, who had attachment difficulties or something like that. Generally, your experts will guide you in terms of whether the peer group is appropriate, but these are things to be thinking about. Age differences can be very pertinent. Is it proposed that your 12-year-old child is going to go into a class where there are 16-year-olds? That can happen in a specialist setting. Is that appropriate? It depends on the circumstances, but it's worth thinking about. What sort of genders do you have in that class? So, for example, with autism, with children with autism particularly, there's still at the moment a preponderance of male children diagnosed with autism, and female children can tend to be mostly in the minority. And so if you're looking to place a girl with autism, you would probably think about trying to fit her into a class where there were other girls there and she wasn't going to be the only girl in a class full of boys. So these are all things that you would think about when you're looking at peer group. And other questions, if your child is wheelchair bound, are they going to be in a class full of children who aren't wheelchair bound, or are they going to have peers who are in wheelchairs so that they don't feel like they're the only ones there, and so on and so forth. Qualifications of staff can be important. This is really where your specification under Section F will be important, because under Section F, you'll be talking about what qualifications staff need. Do they need specific qualifications in autism? Do they need a certain level of experience in teaching children with Down syndrome? Do they need particular dyslexia qualifications? Do the teaching assistants need to be qualified to a particular level? So these are all going to be concerns under unsuitability. When we're talking about lack of appropriate in-house staff, is the child in a situation where their needs are so complex that they need the school to have embedded therapy delivered by an on-site team? So in other words, does this child need a school that has speech and language therapy support throughout the week from a qualified therapist, as opposed to a therapist who comes in one day a week or is brought in and doesn't have a link with the school? We often talk about multidisciplinary teams being needed to set targets and integrate therapeutic targets into the curriculum. So that's another thing to think about. Is that needed? What's the environment like? So, for example, if you have a child with really significant sensory issues, a child who maybe has ADHD or ASD, are they going to be able to cope with a mainstream environment, a sort of 600 to 1,000 pupil school with a big site, big echoing corridors, lots of noise, everyone moving around the school at the same time? For vision impairment, is the school going to be safe for them? For hearing impairment or auditory issues, what are the acoustics like? And there are specific experts who can help you with these things. There are qualified teachers for the deaf, qualified teachers for visually impaired students. There are audiologists who can help you with whether or not an environment is appropriate. What about the commute? Does the commute work? Can the child travel to the school? So if you have a child with ASD who has difficulties with change or transition or transport, how are they going to get to the school? Will they be able to manage that commute? How long is the commute? Generally speaking, the tribunal would be very concerned. I think there's no hard and fast rule, but the tribunal starts to be concerned about commutes where they're over an hour to an hour 15 minutes. And if you're talking about over that sort of time, the tribunal will probably be saying it's either a closer day school or it's a boarding school. So these are all, that's just a sort of taster of the various different concerns that can arise under unsuitability. And it's really worth drilling down into what the school offers if you're trying to persuade the tribunal that it's not right for the child. And the last thing is qualifications that are offered. If you've got a child with high functioning autism, it's likely that they're going to be able to take national curriculum qualifications, GCSEs, A-levels, and you'd really want to be sure that the school that's proposed can offer those qualifications, and they're not going to be stuck with a very small selection or no qualifications that would get them to where they want to go. So moving on. Looking at what it means when the parent school is incompatible with the provision of efficient education for others. This is relatively rare. It's relatively rare, but it's not completely unheard of. So it's worth bearing in mind that firstly, incompatibility does mean incompatible. It doesn't just mean a negative impact. It doesn't mean prejudicial to. It must be incompatible with. And that has been found to be a high bar, and there needs to be specific evidence that enables the tribunal to make a positive finding that school would be, that placing the pupil in that school would be incompatible with the efficient education of others. And the case for that is a case called Hampshire against the Crown and Sendist, which is a 2009 case in the High Court. And again, I will put these references in the chat box later in the talk. When you're thinking about the impact on the other children, the question is, what is the impact on all or any of the learners at the placement? So we're talking about the children or adults that child will come into contact with on a day-to-day basis. So for example, if you have a child who is so anxious and dysregulated that they are regularly lashing out at other children, perhaps they are very violent, perhaps they throw things, perhaps the classroom would have to be regularly evacuated so that the child could be calmed down because there isn't a quiet space for them. Perhaps the child would need repeated physical holds, which is not something that most mainstream schools would offer, for example, or indeed some special schools. These are all things that might be considered incompatible with the efficient education of others. So I have successfully argued that a school would be inappropriate for a child in circumstances where the classroom was being evacuated on a regular basis because there was no other way to manage the child safely when they had a meltdown in the classroom. And the result was that the other children were regularly having their education disrupted and having to stand in the playground for considerable periods of time whilst this child became more regulated. The other thing is that where a placement is full, so over its published admission number, that may mean that their admission is incompatible with the provision of efficient education for others, but it doesn't necessarily mean that. So it's really, you'd have almost a mini admissions hearing, which tends to be about what the prejudice to the school would be of admitting the child versus the prejudice of not admitting the child. It's a kind of balancing exercise between those considerations. And I've already talked here about the child's needs being fundamentally incompatible with the needs of the other children. So moving on. So the next factor is the school incompatible with the efficient use of resources? So this is a costs argument. This isn't really about whether or not a school is suitable for the child's needs. A school can be suitable for the child's needs and meet those needs. The next question is it a good use of public money effectively? So in this scenario, the local authority might accept that parental preference can meet need, but they may argue that there is a substantial cost difference. Broadly, we're talking about a cost difference over £5,000. So the local authority, and if it gets that far, the tribunal, have to balance the statutory weight that's given to parental preference against the extra cost of the other setting to decide whether the extra cost is inefficient. And a general rule of thumb is around the £5,000 to £8,000 mark. Anecdotally, what I find is that the local authority may be open to negotiation on school places if it's clear that they're less than £10,000 apart. And if they are obviously less than £10,000 apart, whilst £10,000 of itself isn't a marginal difference, that's the point at which the tribunal might start saying to the parties, can't you work something out because these schools really aren't that far apart in terms of money. I mean, it's a bit of a movable feast. There isn't a hard and fast rule that the schools have to be £5,000 apart in cost or more. There isn't a hard and fast rule that it couldn't be, that the marginal difference couldn't be less than £5,000. So a tribunal could in principle say, well, £3,000 difference is a significant cost. It's an inefficient cost. But in practice, it tends to be around the 5 to 8 mark. Okay, and moving on. Where the tribunal finds that the extra cost is inefficient, the tribunal then has to balance the extra cost against any extra benefits that it's claimed to bring for the child. This tends to be a slightly difficult argument. Where it's relevant, I think, is that you sometimes have a situation where, in principle, a school might be able to meet need. This happens a lot where the LA has identified a school and the child in question has become a school avoider or school phobic, so they're really struggling to get back into school at all. And what you sometimes find is you can make an argument in principle that if the child would attend the school that the LA is proposing, their school might be able to meet need. But the child has become so very opposed to the idea of attending that school for whatever reason. Perhaps they had a bad experience at a taster day, or perhaps they're displaying a sort of classic rigidity that comes with their diagnosis, and it's just not really possible to talk them into trying that school. The tribunal might say, well, you know, the placement is just going to be unworkable. You know, the LA school might meet need, but what's the point if we can't get the child to go there? And it's only if the extra cost is significant that the parentally preferred placement is displaced, as we've already said. I wanted to talk a little at this point about residential provision, because it's quite often the flashpoint in these cases. So residential placements are much more expensive, obviously, than day placements, generally speaking, for very complex children who require waking day curriculums, so extended curriculums, or require a 52-week placement as opposed to the normal school year of 38 weeks. These placements can be £100,000, £150,000, even £250,000 to £270,000 for children who are very complex. So they're very expensive. They tend to be out of the reach of all but the most wealthy parents. You could be objectively extremely wealthy and really struggle to have the disposable income to meet that kind of cost. Where residential provision tends to be granted is either that there is a specific need for the child to have an extended day curriculum or a waking day curriculum, by which we mean that the child requires programs of education outside the normal school day. And in practice, that kind of curriculum tends to be provided by residential settings. In principle, it wouldn't have to be. You could potentially do that by bringing provision into the home, but overwhelmingly in practice, if you want a waking day curriculum, you need to go to a boarding school to get it. Your child needs to go to boarding school to get it. And a couple of examples of where that might be appropriate would be where the child has a condition. So I appreciate I've mentioned autism a number of times here, but for example, some children with autism will have difficulty generalizing their learning between settings. So they might be able to learn something in one setting, but then struggle to understand how to apply that learning. Say they learn something at school, they find it hard to apply at home. They learn something at home, they find it hard to apply at school. And those children need to learn their skills in different settings. So they need to be taught them at school, and then they need to be taught them at home. So that's one reason why you might have a residential setting where there are teaching staff both at home and at school, and where home and school are very close to each other, so that they can consolidate those skills in both settings. There may also be children who are very anxious or dysregulated, and those children may struggle with transition, so they may not be able to cope with a daily commute, they may not be able to cope with transport, they may arrive at school so anxious from the process of getting ready to leave home and come to school that they lose a lot of their school day to calming down before they're ready to learn. Those children will benefit from, or may need, a school where their home is very close to where they're going to be educated, and again in practice that will be residential provision. Or they might be so anxious or dysregulated over the day that they may not be ready for learning within the normal school day, and so they may need a system of education where they can be taught whenever they're ready for learning. It is important to bear in mind that a waking day curriculum is not about having children sitting in classrooms until 7 o'clock at night. And that, unfortunately, is a misconception that is still alive in some parts of the LA and the Tribunal, where they'll say, well, surely the child needs some rest. But it's important to bear in mind that waking day provision does not work that way. So that's the first situation that residential provision might be granted, where there is a need for an extended day curriculum or a waking day curriculum, programs outside the school, the normal school day. The second situation would simply be there is no day school that can meet the child's needs. So the child doesn't need particularly to be in residential education, but because of where the child lives or because of provisions within the child's area, it's just not possible to find a day school that is within reasonable commutable distance, so within an hour, 15 minutes away. And in that situation, again, if a residential provision is the only one that can meet the child's needs, it will be named, even if in principle the child could be educated in a day setting if there was a day setting that was close enough or could meet need. Okay, moving on. Sorry, Aimee, thank you. So in terms of what costs are to be taken into account, Section 39(4) of the CFA requires the local authority or tribunal to look at the resources of the local authority itself. However, for slightly bizarre reasons, Section 9 of the Education Act 1996 is still in force, left over from the previous regime of statementing under the Education Act. And that requires the tribunal to take a holistic look looking at public expenditure generally, rather than just the resources of the LA. This is quite a complicated area that's probably best suited to specific questions rather than trying to shoot, because you could almost do kind of an hour or so on this. So in terms of what costs would be included, examples are placement costs. These vary depending on the type of school. You're doing a comparative exercise. So if both schools cost £10,000 in terms of placement costs or fees, they would cancel each other out on placement costs. You look at the cost of therapies. Now, it's important to bear in mind, the local authority will generally say, we have a commissioning arrangement with NHS services. So we have commissioned speech and language therapy services for our schools within our borough, and we have commissioned occupational therapy services. We've already paid for them. There's no additional cost because we've paid for them already, because the costs to be taken into account here are the marginal costs or the additional costs rather than costs that would be expended in any event. So it is useful to just drill down into what commissioning arrangements cover. I quite frequently ask the local authority to disclose its commissioning arrangements, because quite often NHS commissioned services such as speech and language therapy won't include direct one-to-one therapy to be provided in schools, or they will limit it to specific situations such as children with speech production issues. They may exclude children who have social communication needs rather than language disorders. They may not provide sensory integration, which is quite a niche specialist occupational therapy provision, which many children with autism or ADHD will need. So it really is worth looking into it, because the LA's blanket position tends to be commission services cover everything. And it is worth just saying to them, well, not if your commission services don't cover the thing that this particular child needs. And then the costs of any one-to-one support or two-to-one support for particularly challenging children. If they need a full-time TA, it's worth thinking again, and you'll have done this in section F, what qualification does that TA need? But the costs of a full-time TA, for example, will be anything from £18,000 a year to £25,000 a year. So that's something that can significantly increase costs. And the costs of any equipment that are specified in the EHC plan for the child. Travel costs will also be included if they're not marginal. So if there is an additional travel cost for children, that will also be taken into account, again, for both schools. The local authority does not always produce these travel costs in time for the hearing. So often they will produce a simple statement that will say something like travel costs will be £120 a day, or travel costs will be £18 a day. Or they may say something like, if child does not require an escort, they will be X. If child does require an escort, they will be Y. If child can be added to an existing taxi route, there will be no cost. If child can't be, etc., etc. It's okay to say, well, this isn't sufficient evidence, and to say to the tribunal, there's just no certainty on these travel costs. For our school, you shouldn't take them into account. Now, sometimes the parental school will attract travel costs that are significant, but when you take away the travel costs, the placement costs aren't actually much higher than the placement costs for the local authority school. And it's worth noting that parents can take travel costs for their own school out of the equation, so make their own school cheaper in the costs assessment by undertaking to arrange travel themselves. And they can make that undertaking to the tribunal or to the LA, and they can simply say, for our placement, we will arrange travel ourselves, but if you name the LA school, the LA will have to arrange travel. And that can actually significantly reduce costs. What I would say is it's probably not worth making that concession unless either parents want to do travel themselves anyway, which many parents do, they'd rather take their children to school themselves, or if it's going to reduce the cost difference to that marginal place of £5,000 to £8,000 or lower. Okay, so that concludes what I wanted to say in relation to section I. I have to say there's an awful lot more that we could say. I'm not sure that you could shut Aimee and I up about this area generally if we had more time, but I